Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. We are going to empower you even the more today. Every pro se should have a copy or access to the federal judge Benchbook. The Benchbook provides an overview of legal procedures for a judge. It's also used by judges while hearing cases as guides to assist them in the disposition of a case. In other words, the bench book helps the judge stay in compliance. As well, it's important that the pro se know and understand the duties and the responsibilities of a judge. The bench book addresses criminal and civil matters, but for the purposes of this video, we will be discussing civil proceedings. You are going to find this bench book very informative and helpful. So let's get started. Case management. What is it? This is where the parties and the court manage the lawsuit. And this is what it looks like. The court may require that the parties participate in a pre-trial conference. And one of the things the court favors in these conferences and really pushes is for the parties to expedite the process and also discuss ways in which they can reach settlement. And this is found at Federal Rules of Civil Procedures, Rule 16. When authorized by local rule, the judge must issue a scheduling order. But prior to the judge issuing the scheduling order, the parties, plaintiff and defendant, would have met to discuss the management of the case. That's Federal Rules of Civil Procedure 26. It's called the 26F Conference. The parties discuss things like discovery, filing deadlines, and other things that would help them to manage the lawsuit. So after the plaintiff and the defendant have discussed management, they reduce what they agree to in writing. They submit it to the judge, and then the judge will hold the scheduling conference. The judge, the plaintiff, and the defendant will discuss what the parties came up with, and eventually there will be a final agreement which the judge will sign. And once that document is signed, that becomes the management plan. And the parties are expected to follow that plan. However, there may be a clause in the scheduling order placed by the plaintiffs or by the judge that states that the parties can move to amend the scheduling order. So here, plaintiff, you have an opportunity to let the court know what you would like to be included in the plan. And don't be shy about it. As long as it is feasible, the judge will look at it and the judge will make the final determination. And that's so even if the plaintiff and the defendant disagree on some points. The judge will eventually make the decision. And let me say something about the district court referring the lawsuit to a magistrate judge. During these conversations, during these conferences, the plaintiff and the defendant actually will have the opportunity to say whether they would consent or not consent to the district court referring the case to a magistrate judge. And pro se, no worries. The judge would not get upset if pro se does not consent to that case being referred to the magistrate judge. Next, finding of fact and conclusions of law. The law is when a judge tries a case without a jury or an advisory jury, the court must find the facts, specially, and state its conclusions of law separately. Why? Well, for one reason, the litigant wants to know the trial court's ruling. Another reason would be the record would be preserved for an appeal. The trial outline. It is so wonderful to read a book that a judge uses and it details the steps taken in a civil trial. That's what this bench book does. It includes the jury selection process. Of course, each judge has the flexibility to use the process that they use in that particular district. However, when it comes to making a preemptory strike to remove a juror based on the juror's race, the judge must follow the three-step inquiry, which was established by the Supreme Court in resolving the move to strike. This is called the Baston Challenge. And the Supreme Court expects the judge to follow the three-step inquiry. And I raise this because the Baston Challenge is often raised in these jury trials. Then there are voir dire questions that are propounded to the jury pool. And this section even have questions, real questions that a party can propound to a jury pool or the individual juror. And then regarding jury duty, it covers preliminary jury instructions at the end of a case, and it covers information on the verdict. So, this is a very informative book, and actually, it's a good read. And I am going to leave a link on the last page of this video and in the description page of this video where anyone can download this book for free. I want to give a shout out to Artemis Elias. He contacted me and said that he uses the Benchbook. And I thought, this would be a good idea to share with the Pro Se family. Thank you, Artemis. I'm Advocate Lucinda, your empowerment lawyer.